Court will call the matter of the Ranches of Rosebrook versus Anise Battle, case number 25C 1245.
Good afternoon, Your Honor. David Fantera on behalf of the plaintiff.
Ms. Battle, could you please state your name?
My name is Denise Battle.
Thank you so much, Ms. Battle. All right, today's the day and time scheduled for a hearing in this matter. This is an action to terminate the tenancy based on non-payment of rent.
Yes, Your Honor. I object to these proceedings moving forward because, like I said, I do have a verified petition in emergency motion for injunction in the U.S. District Court, which is the case number 25-CV-11233.
Thank you, Ms. Battle.
And like I said, this court has not put on the record of their jurisdiction. There's nothing on the record, and it stands. Every notice that I've sent is unrebutted, which stands at law. And jurisdiction is a threshold issue that we shouldn't even made it this far without discussing proper jurisdiction.
All right. Anything else, Ms. Battle?
As of right now, no.
Okay, thank you.
But I object to these proceedings in jurisdiction, subject matter, and personal.
All right, your objection is noted for the record. Ms. Battle, I've already ruled on jurisdiction when we were here last time. We will be proceeding today. The court does have jurisdiction. Mr. Fantera, and Ms. Battle, do either of you have...
I object. The court cannot declare its own jurisdiction to respond to it.
If you keep interrupting me, ma'am, you're going to get held in contempt of court, and the court does have contempt powers, so you're in jail.
I interrupted you. Okay, that's all.
Your Honor, I want to point out also that Judge Vandenberg actually addressed this issue last Wednesday and said that the 14B District Court and Your Honor does have jurisdiction over this matter. So not that it needed to be.
May I add, Your Honor? Yeah. She also said that she was not aware of the things going on, so she just went on for anything based on what he just said. She said any law nor facts, just as you don't, of why you have jurisdiction.
This case is one of those situations where paperwork fantasy collides head-on with legal reality. On one side, we have a property owner following the very ordinary, very boring rules of lease agreements and rent. On the other side, we have a tenant convinced that by using the right combination of legal buzzwords, she can simply declare herself free from every obligation she agreed to. Today isn't really about rent. It's about the growing movement of people believing that contracts, jurisdiction, and courts are optional if they simply refuse hard enough. But courtrooms don't run on belief systems. They run on law, evidence, and procedure. As you watch this unfold, pay attention to something important. She doesn't argue the facts. She doesn't say I paid or the landlord breached first. Instead, every defense hinges on the idea that the court itself magically lacks power, even though she keeps voluntarily appearing inside it. That contradiction sits at the center of today's hearing. And as you'll see, Judge Washington has run out of patience for circular arguments and buzzword incantations. Buckle up. This one spirals fast.
All right, thank you. Again, Ms. Battle, this court has jurisdiction and we will be proceeding today. Mr. Fantera, actually the both of you have an opportunity at this time to do any opening argument that you want to make. So, Mr. Fantera, I will start with you. Do you have an opening statement?
I'll waive my opening statement, Your Honor, and just get right to the evidence.
All right. With respect to service, can you please put on the proofs regarding the service in case there is an appeal?
Say that again, Your Honor.
Can you please put on proofs regarding service in the event that there is an appeal?
Mean service of this lawsuit?
Yes, on Ms. Battle.
I believe that she was served by a court officer with Jimmy Moore's office, Your Honor. I think there's a proof of service in the file. I don't know whether it was attached or whether it was personally served. But the court has that proof of service.
With respect to proof of service, the file indicates that Ms. Battle was served with two different ways pursuant to MCR 4.201B. which is she was served, actually 3 different ways. She was served with an original mailing from the court, and then a second mailing went out from the court. Second mailing was requested by the plaintiff and was sent by this court. On March 28th, there was a mailing. And then there was service by Edward Cope, who was the court officer. That service was effectuated through securing an attachment to the main entrance of the tenant's dwelling unit. And that was done on April 4th, 2025. And after attempts had been made on April 2nd at 12:40, and then April 3rd at 9:53, they finally did an attachment on April 4th at 4:30 p.m. In addition to that, Ms. Battle showed up to the court on April 9th, 2025 before the magistrate, therefore acknowledging that she had received service in this matter and that service had been perfected. Right. With respect to jurisdiction, we addressed that at the last court hearing. This is in Russell Court, which is within the jurisdiction of Ypsilanti Township. All right.
Yeah.
What request were you making, Mr. Fantiera?
I know the last 2 times that Ms. Battle has appeared, she appeared with a video, and this time she's just on her phone. Can we require her to be here by video today also?
I would have had to give
Well,
her.
the thing is like I tried to tell you all last time that the time was bad. This is when I pick up my kids.
Here we see a familiar sovereign citizen pattern. Provoke the court, then claim to be a victim of the very authority you just challenged. The judge isn't threatening jail because she asked questions. She is interrupting repeatedly after being warned, refusing to follow procedure while still demanding the court honor her arguments. Contempt isn't punishment for opinions. It's a tool courts use when someone disrupts the legal process itself. Notice how quickly the tone shifts the moment consequences are mentioned. The courtroom goes from philosophical debate back to order, proving once again that these theories collapse as soon as real accountability appears.
All
So
right,
if we
then
can do it like earlier or something of that nature, yeah, that's fine.
then I'm okay just proceeding as long as the court is comfortable that we can swear her in when she goes to testify.
Thank you. I am comfortable. I can tell you that if I was going to require that she be here via video, I would need to give her notice of that prior to today's date. So I'm comfortable proceeding as we are.
Okay.
All right. And Ms. Battle, other than jurisdiction, which has been noted and reserved, do you have any other argument you want to make today with respect to this matter in terms of an opening argument?
Of course. So, like I said, the contract has been rescinded on April 1st, and it was due to unconscionable pieces in the contract, including pieces that's wrong with the formation, as well as material breaches that's inside the contract. That contract has not been
You said
material breaches.
Oh, okay, go ahead.
Breaches, yes, within the contract as well. That was sent out and received. Well, it actually wasn't received on April 1st because at the end of the day, the unconscionable pieces, their addresses are wrong and the owners are wrong on the contract, so it got sent back. But once I realized it was sent and received on April 8th, 2015, and still remains unrebutted. They have yet to unrebut it in any case that we came and talked about the contract. And by law, according to Wall versus Zendaya, the Michigan law recognizes rescissions at common law for breach, fraud, and unconscionability. Meaning, if I give notice and it's unrebutted, that stands at law. Also, I've talked on personal matter jurisdiction, in why I came in under special appearance the first 2 hearings. because at the end of the day, I'm not a legal person. I'm not in a legal capacity under Michigan law. I do not qualify as that person, which that person is a corporation, a trust, an individual, in some type of legal entity of that nature, an association. I do not qualify as one of those people to be here and subjected to this without consent. Hence why, things were sent administratively and defaults were given administratively, because things are happening right here where I'm being deprived of due process and I should be awarded due process.
Right there captures the entire sovereign citizen mindset in one breath. You have no authority over me, but also please recognize my motions, my filings, and my arguments. Authority cannot be selectively real. If the court has no power, then nothing filed here matters, including her own objections. Yet she clearly believes it does matter because she keeps showing up. Judges see this every week. These aren't clever loopholes. They are misunderstandings dressed up as strategy. And while the rhetoric sounds confident, outcomes like eviction and judgments keep proving which side of reality the law lives on.
Attorney stated last time we were here, he was saying that basically the burden of proof only applies in criminal cases, which is false, because the burden of proof applies in all civil cases where jurisdiction or contract validity challenged, and that's Taylor versus Bullam in 1992 in Michigan. You still have the burden of proof. The court cannot establish their own jurisdiction being based on a contract is rescinded. You have to have a valid contract to come into court about. So that's where your jurisdiction of the subject matter is at hand, because the contract is rescinded, not unilaterally, like he's tried to claim before. It is rescinded, meaning I gave you notice and it's unrebutted, just as if somebody came into the courtroom for an eviction, or if they did not come for the eviction, you'll give them a default, because what happens at law, your silence stands.
All right, thank you, Ms. Battle. Mr. Fantera, you may proceed with your case.
Plaintiff would like to call Dawn Charles as a witness.
All right, Ms. Charles, please raise your right hand to be sworn. Do you swear or affirm that the testimony you're about to provide will be the truth, the whole truth, and nothing?
I do.
Thank you. You may lower your hand. You may proceed.
Ms. Charles, please state your name for the record.
Dawn Charles.
And what is your position with the Ranches of Rosebrook?
I'm the property manager.
Are you familiar with the tenancy of Anise Battle?
I am.
Are you familiar with the lease agreement that she signed?
I am.
Your Honor, I submitted to the court a lease agreement dated November 12, 2024. I'd be moving for that to be admitted as Plaintiff's Exhibit 1.
Did you also provide a copy to the defendant?
I did not, because I do not have her email address. But she should, Your Honor, I should say for the record, she should have a copy of the lease, because it is, because she signed it.
Any objection?
I never received a hard copy of the lease, and I've asked for a hard copy of the lease, never received it. And as I read the lease, that was also a breach of my lease, as I was supposed to receive it and sign it in person, as they made me sign it over online. So again, the information that he's saying about the lease is correct. I'm not here to argue about the lease as far as what the original contract was. I'm arguing about the validity of what it is now, which is invalid and void because it's been rescinded.
This is another subtle tactic that appears often. Shift the focus away from the legal issue and toward personal inconvenience. The hearing isn't scheduled around anyone's daily routine. It's scheduled around court availability and legal deadlines. Judges aren't being rude. They're making sure the law applies fairly to everyone. And again, the core issue resurfaces. If rent had been paid, none of us would be here having this conversation. Life obligations don't disappear because timing is inconvenient. Courts don't evaluate how busy you are. They evaluate whether agreements were honored. And right now, the facts seem pretty simple.
All right, given that she's not arguing about the validity of the lease itself, I will allow the exhibit
You know,
one.
I said I did argue about the validity of the lease as far as it being valid, because it's not. But I'm not arguing that I entered into a lease on or around December 6th. That's not what I'm arguing. I'm arguing the validity of the lease. So let's correct that.
You're arguing, you're not arguing that you entered into the, what are you arguing?
Like I said, I do not object to actually entering into a lease. What I thought was, yes, a proper lease or on or around December 6th. I do not deny that, but I do deny the validity of the lease because the lease has been rescinded and it's unconscionable. Yes.
Thank you. Your argument that the lease is rescinded is not the lease from being admitted. The lease is admitted. That objection is overruled.
On what facts of law?
The fact that I just ruled that, ma'am.
That's not a fact or a law. So let the record show
You're
that
not
he has
going,
no
the record
no law
shows
or no merit to
everything. The
object.
record shows everything,
I got
ma'am.
you.
You don't need to say that. And please
I know
stop.
it will when I pull the transcript because, like I said, this case is also.
All right, Mr. Fantera, you may proceed.
Okay, I want the record to show that I find it unfair that you can cut me off and use my mic whenever you
This
feel
is your
like it,
second
but I
time.
can't
You're
talk
being
and have a
held in
fair
contempt of
hearing.
court. You're going to be held in contempt of court, and you're going to do jail time.
This is where things get especially fascinating and legally baseless. She argues she is not a person under the law because she believes person refers only to corporations or artificial entities. Unfortunately for that theory, courts have clarified this countless times. A person includes human beings. It's not a trick word. It's just legal language used to distinguish individuals from governments or groups. By claiming she isn't a person, she hopes to sidestep every obligation attached to identity, leases, jurisdiction, contracts, accountability. But reality doesn't bend around wordplay, and legal definitions don't vanish because you disagree with them.
Mr. Fantera, please proceed.
Ms. Charles, can you, under the terms of the lease, what is Ms. Battle's monthly rent?
$10.75.
$1,075?
Correct.
Does she also have to pay utilities?
Water and sewer.
So for what months has she not paid her rent?
March, April, and now May.
So she owes $1,075 for each of those 3 months.
Correct.
Has she, does she owe the water and sewer for those 3 months also?
Yes.
How much does she owe for those months?
Her water and sewer.
Yes.
So March is $36.24.
April?
$35.45.
May?
$35.73.
Okay. That totals $107.42, correct?
Correct.
Are there late fees under her lease?
There are
What is the late fee?
$50.
On what day?
The 6th.
And so she's being charged a late fee for March and April, correct?
Correct.
So the total amount that she owes is $3,225 in rent, $107.42 in utilities, which is also rent, $100 in late fees, and then she would owe the court costs of this in this matter, correct?
Correct.
Have you reviewed the work orders that have been submitted by Ms. Battle since she has been a tenant?
Yes, I have.
Are you comfortable that they were all completed in a timely fashion?
Yes.
No further questions, Your Honor.
Thank you. Ms. Battle, do you have questions for Ms. Charles?
Yes, I do. So the first working order, are you able to disclose, or do you know firsthand what that was?
Your first work order was your shower water wasn't hot. You had some screws in your hinges that weren't secure. And when the water was turned on in the tub, it comes out of the shower as well.
Okay. So how do you define complete? How is that work order complete?
Well, that was the work order you put in. The notes for repair are that the diverter for your hot water was repaired. Our construction company fixed the tub faucet that had came off, and we installed new screws in hinges on the door.
Right. So do you have anything that the actual construction company came, because nobody came? Because even if you go on to the next 3 orders,